And Miss Fatima,
Yes, Judge.
the IT folks brought me a new Surface yesterday for my real time, and it keeps turning going dark, turning itself to sleep, I guess. Will you see if somebody can come help me fix that?
Yes, Judge.
Thank you. All right. Well, does anybody know who Justice Baker was representing?
That's on the Dodds case, Your Honor.
Okay. We do have two cases set this morning. We had three, but one of them has passed. So let me just announce the two cases, Dodd's case, and y'all have a motion for continuance. All right. Welcome back, Justice Baker. Can you hear me?
Forgive my name on that screen. It needs to be updated.
No problem.
I can
No.
hear you, Your Honor. Sorry, I didn't mean to be inject levity in this.
Not a problem. The problem is that you are breaking up. Your voice is breaking up. So,
Judge, can I make a confession here right out of the gate?
sure.
Our internet where I'm working is horrible. I'm using my personal iPhone hotspot to try to stay connected with you. I just did a mediation where it was horrible. The internet kept going in and out. The court and all people there in this case. I have no control over it. I just had somebody from the office here assisting me because I am not tech savvy.
All right. Well,
But I've got my personal hotspot here to try to keep me connected with you. It says your internet connection is unstable. I get that from my screen.
yeah, you might be better off going to your phone, but hopefully we can get this to work. So, tell me who you represent. I understand you're in the Dodds case.
Yes, ma'am. Yes, Your Honor. Sorry. I'm working for Mr. Pritchard's office in Killeen, Texas, and our office represents Mr. Dodds. Now, I have not been his attorney up till before now in the case. He had a prior attorney who no longer works at this law firm. And that's my part of my what you'll hear on the motion when you're ready.
All right. Thank you. And Miss Henson, you represent?
Miss Sarah Dodds, Your Honor, and so Justice Baker is aware the continuance is no longer opposed. I communicated that information to his office, but I didn't realize Mr. Baker was now representing Mr. Dodds.
All right. Well, that was why we were going forward today on the motion for continuance. So if the
Didn't get the
parties,
word, Judge. Sorry, Judge. I didn't mean to talk over you.
if the parties agree, have y'all got an agreement on when you'll reschedule?
We have not, Your Honor, but I don't mind communicating with his office to get that set up. We haven't had issues getting settings scheduled in the past.
Judge, counsel sent us a list of mediators, none of whom were familiar to me. And I asked some other people about the mediators, and I was going to try to get counsel. I was going to try to let counsel know a mediator off of the list or make a suggestion for somebody else that's maybe not on the list, but I'll do that as soon as possible. And there's also a motion for a guardian ad litem, Judge, but that maybe is not on the docket. I don't know if it's even e-filed, but it's in my file, my paper file.
All right. Well, the only thing I show on my docket that's set for today is the motion for continuance. Is that your understanding, Miss Henson?
Yes, Your Honor.
All right. Well, if y'all have agreed to the motion for continuance, then we will pass the hearing and we'll note in the docket notes that you all have agreed to reschedule.
Thank you, Your Honor. May we be excused?
You may. Thank you. Good to see y'all.
You as well.
Thank you.
Good
Good day.
Honorable Jan Soifer
Bye.
presiding.
Thank you.
All right, so we are here on the motion to enforce, and I believe the live pleading is the second amended motion for enforcement that was filed January 17th of this year. Let me hear announcements on who is representing whom. We're here on the Sibly matter.
Thank you, Your Honor. Amanda Andre for Erica Sibly.
Good afternoon, Your Honor. This is Joe Sibly, attorney acting pro se.
All right. So we have 3 hours, an announcement for 3 hours. We are gonna take that time and divide it in half. Mr. Beck will keep track of the time. I do have, actually a couple coming in to get married at 3:45. And so we're gonna need to take a break then. So we'll take our afternoon break at about 3:45 unless anybody needs one earlier. Miss Williamson may need one a bit earlier, so we'll take our cues from her, but we'll need about a 5 or 10 minute break at 3:45 either way. All right, so Miss Andre, would you like to make a short opening statement?
I would, Your Honor, and I'll try to keep it short. I'll do my best.
And I have reviewed the pleadings.
Okay. Well, and I'll say in some ways today is very simple because Mr. Sibly, from his own pleadings, I don't believe is disputing the fact that the contractual alimony payments in the final decree and the Tesla loan payments in the final decree have stopped. And they stopped around last July and August of 2024. By his own admission and multiple pleadings, he stated he paid 6 or 7 months worth of the court-ordered payments, and then he excused himself from these payments, claiming that he had the right to do so because of the consulting agreement that Ms. Sibly had not previously signed. So she has since signed the consulting agreement, but the consulting agreement and the alimony and the Tesla payments, they're not conditioned upon each other. So there was nothing in the decree that states if Ms. Sibly does not sign the consulting agreement, then Mr. Sibly does not have to make these payments. So at this point in time, as of today, we believe he's behind $24,500 in the alimony payments. There was a total of 36 months in total. And then in addition, the car has been repossessed. My client is a teacher. She's a 5th grade teacher. She makes about $52,000 a year. Quite frankly, she doesn't have the funds to continue this legal predicament that she's in. She also lost her car and her credit has been ruined. She didn't realize at the time that Mr. Sibly got the loan, he had added her to the loan, and so now her credit shows all the late payments and the repossession, and she can't get herself another car. So she's also incurred expenses of renting a car for the time being because she's stuck. The decree also stated that in the event of an enforcement, that Mr. Sibly shall pay 100% of Ms. Sibly's attorney's fees for a motion for enforcement. So specifically, this cause of action enforced in this manner under Chapter 9 of the Texas Family Code. Mr. Sibly, I believe, is going to be arguing, according to all his pleadings, that this is a breach of contract case, that it can't be heard under Chapter 9. He keeps referring to contempt. We didn't ask for contempt. We're not asking for contempt. He's stating that it can only be heard by a civil court, not by the family court. Even his own case law that I believe he's uploaded says you have a right to file a breach of contract claim. It doesn't say we are precluded from filing our enforcement under Chapter 9 of the Family Code. I believe he also has a jury demand or 2 jury demands on file, and under Chapter 9, you are not entitled to a jury. So Chapter 9 is very clear about enforcement of property division and any contractual provisions under the terms of the decree, which is what these are contractual provisions. Our fees in this matter, unfortunately, are $30,000 through today, in large part because of Mr. Sibly's actions. We emailed him a letter warning him that we were going to be filing a motion for enforcement in October of 2024. He received my email because he responded to my email 7 days later with basically telling me I can't file a motion for enforcement. We then filed the motion for enforcement. We emailed it to him, knew we had to have him served. He evaded service. We had to do a motion for alternative service. We had to get an order for alternative service. We had to amend our enforcement twice because the car then ended up getting repossessed as we were trying to get this set. We moved the hearing date, and today's hearing was set based on Mr. Sibly's availability and by his agreement. He sent us dates, and we picked one of his dates for this hearing. So my client's been waiting a long time to get this matter heard today. And less than 2 hours ago, we were sent by email a counterclaim and third-party petition naming me as a third-party defendant. Clearly an act of intimidation. He's trying to subvert the motion for enforcement from going forward to today. His new lawsuit, which has not even been properly served, is barred by litigation privilege. It's unprecedented, quite frankly. I think Mr. Sibly's, he's trying to void the mediated settlement, the binding mediated settlement agreement from December of 2023 and the final decree from 2024 that was entered in January of 2024, which is not allowed. You can't collaterally attack a court order. And any of his appellate rights have long passed. He could have filed a motion for a new trial a long time ago and filed an appeal a long time ago, but that is long past. Again, nothing more than an act of intimidation. My client needs a car and she needs to receive the funds that were ordered to be paid by Mr. Sibly under the decree. The reason we had these ongoing payments is because it was the only way for her to get a fair and equitable distribution in the divorce. There was no money left in the divorce because it was spent. Mr. Sibly makes probably 10 times, at least he did during the marriage, what my client makes. Again, there's no claims here that he can't make the payments or that he did make the payments. He, in fact, is saying he's just excused from making the payments. So we're also asking for fees in the event of an appeal on top of the $30,000. Normally, I'd say $25,000 in the event of an appeal, but given all the pleadings and different things that have been filed by Mr. Sibly today, I think it could be twice that. We're asking that we get to go forward today on our second amended motion for enforcement. That's it.
All right, thank you. Mr. Sibly.
Yes, Your Honor. Let me give you a little recap of what happened here, and I'm just going to start from the time that the mediated settlement agreement and the final decree were entered. The final decree says that Erica is supposed to sign a consulting agreement with the law firm and receive payments that way because she's supposed to claim taxes on those payments. Okay. We had agreed in the course of arbitrating the final decree with Mr. Royer, Michael Royer, that he would arbitrate any dispute over the consulting agreement and the drafting it. Also, the order to seal the case, which we had agreed to do, which was never done until just recently. And we kind of went back and forth with it. And then after the decree was entered, I sent multiple emails, I mean, for months, asking them to finalize this consulting agreement, because without that, there's potential tax consequences for me to make these payments when she's agreed to pay taxes on them. And she responded with an email that said, I told my lawyers I was never going to sign this agreement. I was never going to sign a consulting agreement because I'm not going to claim that I'm paying taxes on this money. Okay, so apparently she knew when she signed the mediated settlement agreement, and her lawyer knew at that time, as well as the decree, that she had no intention of signing the consulting agreement. So months go by. I had she claims I make a lot of money. My income has been cyclical because of COVID. Okay. And last year, my biggest client filed bankruptcy, and I had probably the worst year ever. But still, I was making the payments because I wanted to get this resolved. Miss Andre never responded to my emails asking for her to seal the case, asking for finalization of this consulting agreement, confirming that the documents they had obtained in discovery had been destroyed, just ghosted me basically. So ultimately, after Erica repudiated the agreement, because remember, if it's anything, it's contractual alimony. So she repudiated her intent to execute any consulting agreement, never sent me a W-9 form so I could properly log this as payments to her that she had to pay taxes on. The payments, according to the pleading, stopped. Ms. Andre sent me a demand claiming that they were going to seek to enforce the final decree. And I responded to her and informed her that this was not enforceable. It's not enforceable by contempt. The court can't issue an order that orders me to pay these things, right? It's a debt division and it's contractual alimony. It's not court-ordered spousal maintenance or child support or something like that. So, that should be undisputed. When I was finally served with the motion, quote-unquote motion to enforce, there's something in the record about a show cause order, which is something that's associated with contempt. There's also references in that motion, Your Honor, and it's in fact in their proposed what they want you to do today, to admonish me, to fines, etc. I don't know what that is if not contempt, and I don't know what we're doing here today, but for that, because this is a notice for hearing on a motion to enforce. It's not a trial on the merits. And under Section 9, it says, I'm not disputing that the court has authority over the subject matter. I'm not disputing that they could file a claim for money damages, but that's not what they have. They don't have a breach of contract claim. They have a motion to enforce. Under Chapter 9, it says when you file a suit, it says suit, it doesn't say motion. When you file a suit for enforcement of provisions in a divorce decree, I'm just looking at 9.001, except as otherwise provided, a suit to enforce shall be governed by the Texas Rules of Civil Procedure. After a party files a written answer, the proceedings shall be governed as civil cases generally. So I don't know what this is. If it's not a motion to enforce by contempt, what is it? It can't be a trial. We don't have notice of a trial. We just answered 30 days ago. None of the things that she has in this Dropbox were ever disclosed prior to hours before this hearing. I mean, this just can't, if it's not a motion to enforce by contempt, and again, she's got in her motion all of the earmark, it doesn't say contempt, but it says warnings, admonitions, fines, penalties. How is that not contempt? What else would that be? So, Your Honor, we object to any hearing on enforcing the motion because it can't be enforced. The way you win on a debt claim, and we have a lot of defenses, the way you win on a debt claim is either by a motion for summary judgment or a trial on the merits. And this is neither of those things. And I sent Ms. Andre no less than 3 or 4 emails telling her that she can't do what she's trying to do today. She can't get me penalized or fined or all of those things. I sent her the case law at least 3 or 4 times. I asked her to set this for a conventional trial. So we could take discovery and do the normal things like Chapter 9 says. It's like a normal suit. She refused to do it. And Your Honor, when you persist in a course of action that you know is violating the law and besides the fact that's threatening someone with criminal penalties over a civil matter. And so we did file a motion for sanctions under Chapter 10. I gave her months to get this fixed, and she refused to do it. The other problem with their claim, Your Honor, is that, first of all, there's a condition precedent that wasn't satisfied. She just signed a consulting agreement that they came up with like last month or a month before. Problem is, it's too late now. That's a year after the payment started. So what am I supposed to do with the tax consequences of the payments that were made last year? I've been damaged because of that. The other problem that they have is, Your Honor, is if it's a debt division for payment to a third party, that's not, they don't have a, she has no standing to sue me for that. She has to make the payments and then sue me for those payments. She can't get an order forcing me to pay a third party. I mean, that's very clear in the case law. So there's a lot of problems here, Your Honor. I don't think we should be having any hearing today because it can't, this order cannot be enforced through a motion. This has to be trial on the merits. They're required to do everything that every normal plaintiff does when they file suit for money damages. Yes, the decree can be enforced, but it's enforced as though it's a contract. We have counterclaims, we have affirmative defenses. No one, you can't, I mean, we can't be expected to show up on a motion to enforce that should have never been brought and have a trial on the merits with all of their evidence dumped on me 2 hours before. That's completely inappropriate. So we would object under the rules of procedure that require proper notice for a trial on the merits. I would object under Rule 215 because none of this stuff was properly disclosed in time for us to be able to, attorney's fees, things like that. That requires expert testimony. I haven't even had a chance to look at these yet. So if what Ms. Andre is telling you now is, oh, we're not really trying to get you to issue an order enforcing this, which is what the motion literally is and what the proposed relief requested literally is, if what she's telling you is now this is just a trial on the merits, that's completely inappropriate. We can't have a trial on the merits today. So, child support, sure, you could file a motion to enforce by contempt and the court could issue an order ordering someone to pay it or, there's contempt. This is not that kind of provision in a divorce decree. And so we shouldn't be here on any motion to enforce. What we should be here on at some point is a trial on the merits after the appropriate rules of civil procedure have applied, discovery, etc. And we have adequate time to develop our defenses to these claims.
So we are going to go forward today. I do see the provision at the top of page 15 of the agreed final decree of divorce that says enforcement fee provision that contemplates exactly this remedy if Erica Sibly is required to file a motion to enforce any term of this agreement and Joseph Sibly is found to be in violation of any of the terms herein, Erica Sibly shall be awarded 100% of all of her fees reasonably and necessarily incurred in pursuit of the filing of a motion for enforcement. So I do find that this exact proceeding is what was contemplated by the divorce decree. We're going to go ahead and go forward. So, Ms. Andre, you may call your first witness.
I would call Joe Sibly, Your Honor.
All right. Mr. Sibly, would you raise your right hand to be
Thank you, Your
sworn?
Honor. Mr. Sibly, can you state your full name for the record?
Joseph David Sibly IV.
Could you confirm your current address?
My current address is...
You're going to need to slow down just a bit, especially on numbers for the court reporter. So I think we both caught the one.
Texas 78701.
Thank you.
Mr. Sibly, is that your office address?
That is the office address for Camera and Sibly LLP.
Okay. And then what is your home address?
Your Honor, I would object to this line of questioning. What does this have to do with the breach of contract claims that they're claiming? What does my personal address have to do with that?
The objection, to the extent there is one, is overruled. Please answer the question.
My current residential address is one.
Is this the residence that you live at with your current wife?
Yes.
And we attempted to serve you at that address. Is that correct?
Your Honor, given the ambiguity surrounding this entire hearing and the lack of ruling on the things that we argued earlier, at this point, I'm going to invoke my Fifth Amendment right against self-incrimination.
All right. Hang on just a minute. That means that I understand you're a lawyer, Mr. Sibly, so this may be unnecessary, but I just want to make sure that you are aware of it under Article 1, Section 10 of the Texas Constitution and the Fifth Amendment of the U.S. Constitution. You can't be compelled to testify or give evidence against yourself that might lead to incrimination. But if you choose to invoke your Fifth Amendment right to remain silent, you must let me know that you are asserting the privilege for each question you refuse to answer. And when you refuse to answer on the invocation of the privilege against self-incrimination, the witness is not the exclusive judge of his right to exercise the privilege. The court is entitled to determine whether the refusal to answer appears to be based on the good faith of the witness and is justifiable under all the circumstances. An assertion of the Fifth Amendment does not constitute an admission of the allegations and does not relieve the petitioner of the need to adduce proof of her claims. But a fact finder, and in this case, of course, that's the court, may draw negative inferences for a party's assertion of the privilege against self-incrimination. In other words, the court may consider your invocation of the right not to answer as evidence that the answer would be unfavorable to you. All right.
Aware of the adverse inference rule, Your Honor, as counsel.
I'm sorry?
As a lawyer, I'm aware of the adverse inference rule.
All right. Ms. Andre.
Thank you, Your Honor. Your current wife's name is Lauren Elizabeth Fogarty, is that correct?
That is incorrect.
What is her name?
Lauren Elizabeth Sibly.
And Mrs. Sibly emailed our process server regarding the service, correct?
I'm sorry, can you repeat the question?
Did Mrs. Sibly email our process server after the process server attempted to serve you?
I do not have knowledge of that.
Did you write an email to the process server?
I did not email any process server in connection with this case, except for the process server who served me personally via email.
When did you stop paying the contractual alimony, Mr. Sibly?
Invoking my Fifth Amendment right against self-incrimination.
Do you recall the last payment being August of 2024?
Invoking my Fifth Amendment right against self-incrimination.
Can you show me what language in the final decree conditions the alimony payments on Miss Sibly signing the consulting agreement?
Are you asking for a legal opinion?
I'm asking you to show me the exact language in the final decree of divorce that conditions Mrs. Sibly's contractual alimony payments on her signing the consulting agreement.
I would object to this question, Your Honor, as counsel. I object to this question as calling for a legal conclusion.
Overruled.
I don't have the agreement in front of me, and I don't know. I can't point you to in the abstract something in the agreement that says what you say, so.
Well, I believe we have uploaded the decree as an exhibit. Have a page number or a paragraph, a section of the decree that references the alimony being conditional.
So I can only give you a legal opinion on this. This is not a fact question. I can give you a legal opinion about the way I read this as a lawyer.
Objection non-responsive, Your Honor.
So I believe the question is, what are you relying on for your statement? What part of this agreement?
What statement?
For
I-
your statement that it's conditioned, the payment of alimony is conditioned on her signing the agreement.
So that statement was made as counsel, argument as counsel. It's a legal position. I have not made I have not given testimony on that. So I'm not sure. This is why this is a problem if we're mixing between legal and factual. I can give you, as a lawyer, I can tell you what I believe is the proper construction of that paragraph if you'd like to know that. But I'm as a layperson, I can't give a legal opinion about that.
Well, of course, you're not a layperson and you are a party who is also a lawyer. So I don't think we need to get caught up in semantics. I think the question is just, what is there in this provision that you base your decision on to stop paying the contractual alimony?
So I've not given any testimony about that. There's no testimony about my decision or not decision. I've invoked the Fifth Amendment on that. I can tell you, looking at this provision, the way I construe it. That's all I can answer, Your Honor. I'm not going to get into factual testimony about the substance of these events, given the posture of this, whatever this is, motion to enforce or whatever.
If I can direct you to the last paragraph in the contractual alimony section, do you see where it says, in the event that Cameron Sibly is dissolved, modified, mutates, or insolvent, this provision on contractual alimony is still binding on Joseph Sibly? Do you see those words, Mr. Sibly?
I see that there are words to that effect on the screen.
So therefore, if your company dissolved, any consulting agreement would therefore be dissolved. Is that not true?
I object to calls for legal conclusion, Your Honor.
Overruled.
I can't answer that question.
Mr. Sibly, do you intend to pay the outstanding now 8 months of contractual alimony that is owed?
I invoke my Fifth Amendment right against self-incrimination.
Do you have any intention of paying the remaining 20 months of contractual alimony that is owed under this final decree of divorce?
I invoke my Fifth Amendment right against self-incrimination.
In addition to the alimony obligation, the final decree of divorce also orders you to make payments for the Tesla Model Y loan with Wells Fargo. Isn't that correct?
I'm sorry, what's the question?
The decree ordered that you make payments, all monthly payments that were outstanding on the Tesla Model Y loan for Wells Fargo. Is that not
that sounds like it calls for a legal conclusion as to what the agreement calls for. I would say the document speaks for itself.
We can go to that section of the decree. So, do you see H4, Mr. Sibley?
I see an H4 on my screen, yes.
Okay, and what does that say?
The words read $48,648, comma, and 75 cents. 48,648.75. The total debt for the Tesla Model Y VIN 7SAY6GEF2NF394809 to be paid on the due date every month until paid in full.
And didn't you in fact make those payments up until July of 2024?
Invoke my Fifth Amendment right against self-incrimination.
Since July of 2024, have you made any additional payments?
I invoke my Fifth Amendment right against self-incrimination.
Are you aware that the Tesla has since been repossessed?
I invoke my Fifth Amendment right against self-incrimination.
Were you aware that the failure to make these payments would result in penalties, damage to both your credit and Miss Sibley's credit, and repossession of the vehicle?
I invoke my Fifth Amendment right against self-incrimination.
Isn't it true that when you purchased the Tesla, you obtained a loan without Miss Sibley being present?
Can you repeat the question?
Isn't it true that when you first bought the Tesla, the Model Y, you obtained the loan without Miss Sibley being present there at the time?
I invoke my Fifth Amendment right against self-incrimination.
In fact, isn't it true that Miss Sibley never signed anything for Wells Fargo related to this car loan?
I have no knowledge of that.
Well, Mr. Sibley, if you went and purchased a car and got a loan for a car, why would you not have knowledge if your wife at the time also signed on the loan documents or was present?
I don't understand the question. I don't have knowledge of what she did or what she didn't do.
So you don't recall if your wife was with you at a car dealership when you bought a $67,000 vehicle for her?
No, you don't buy Teslas from a car dealership. It's online.
Well, was she sitting next to you while you were online buying a Tesla?
I don't recall.
What type of car do you drive?
I have a Tesla Model 3.
Are you making payments on that car?
Yes.
What kind of car does your wife drive?
My wife has a Toyota RAV4.
Are you
in her
making
name
payments
that she had
on,
prior to our marriage.
so are you making payments on that car?
No. My car is paid for, as I understand it.
Do you recall in the final decree of divorce that Miss Sibley is also entitled to 50% of any profits, income, or royalties you receive from publishing screenplays, movies, TV shows, or other entertainment-related deals concerning the Army of Tomorrow.
I'm going to object to this question, Your Honor. There's nothing in this motion to enforce whatever we're here on today that has anything to do with that part of the decree.
Your response to his objection based on relevance?
Yes, Your Honor. It goes to the additional obligations that are outstanding and our concern about future payments related to the alimony and the car. Well, the car is gone now, but because I want to understand Mr. Sibly's intent on complying with all of the terms of the decree.
So I'm going to sustain the objection.
Mr. Sibly, do you recall the agreement and the language in the order that states that if Erica Sibly is required to file a motion to enforce any terms of this agreement, and Joseph Sibly is found to be in violation of any terms herein, Erica Sibly shall be awarded 100% of her fees reasonably and necessarily incurred in pursuit of the filing of a motion for enforcement?
I don't recall the specific language.
Well, we have it here on page 15. Do you see the language with the title, the section titled Enforcement Fee Provision?
I see those words on my screen, yes.
Did you in fact agree to this language in a binding mediated settlement agreement?
I agree that this language appears to be part of the final decree.
Which you signed, correct?
I did sign the final decree, that's true.
I'll pass the witness at this time, Your Honor.
All right. Do you have any testimony you want to offer at this time, Mr. Sibley?
I don't have any testimony to offer, Your Honor.
All right. Ms. Andre, you may call your next witness.
I call Erica Sibly.
All right. Ms. Sibley, would you unmute yourself and raise your right?
What do you do for a living?
I am a teacher of 5th grade history.
What school?
At one of the Ideas public schools in the area.
Okay. And approximately what do you make per year as a teacher?
I know my checks are less than $4,000 a month that I get, so probably about like 52 pre-tax or whatever. When you know how they take stuff out.
And Ms. Sibly, could you do you recall the last payment of contractual alimony that you received by Mr. Sibly?
It was in August of last year, so 2024.
And how did he typically send you those payments?
Direct bank deposit into my account.
Okay. And when was the last payment that Mr. Sibly made on the Tesla Model Y?
I would have to say September. It would have to be.
Objection, Your Honor, calls for speculation.
You may answer if you know.
It would have to be 2 months before September 9th because I got a email from Wells Fargo saying you were more than 2 months behind, and that's what really.
Objection, Your Honor, it's hearsay. What Wells Fargo said is hearsay.
Well, either way, it was you were late.
Okay. Can you tell the court about the day the car was repossessed?
Yes, it was the day before we were supposed to have a trial, which was like February 20th, because the first one got pushed back and then we pushed it back again. And the day before we were supposed to have this, I thought, I go out to my car after work and I am just so thankful. I got scared because I was like, I know where I parked, and it was towards, like, I was one of the last ones out. So I was just really glad that I had a coworker also there, because I was like, I'm not crazy, like my car's not here. And my worst fear came true, that I had been having for months and months, that I'm gonna go out from where I'm at and I'm not gonna have my car.
What did you do?
I asked my friend if she could take me home. And I think I sent you an email.
Did you also contact Wells Fargo?
Um, I I might have. I mean, yeah, I probably did. I mean, I was just, yeah, because I didn't know where the car was.
Okay. It wasn't towed.
Yeah, it wasn't towed. Yeah, no, not at all. In fact, they had to go on the school cameras and they had to find out, like, because I said, did y'all, did you get my cars? They said, we don't tow cars here. And they had to look on it on camera, but it was taken from my work the day before.
I believe we have Exhibit 8 should show the loan payment history. I'm not seeing it in box. Oh, Jay has it. Thank you, Mr. Riggs. Do you recognize this document?
Yes,
Right. What is it?
those are screenshots from my, like, when you see your credit report on your phone, or through your bank, and then it tells you what amounts you have in debt and, like, things that aren't paid, and it wasn't. Yeah, and that's, my credit suffered major. It was starting to suffer after the late payments, and then it really took a hit in, I think, December or in November. It's on there.
Does this show the last payment that Wells Fargo received?
Yes, I would assume, yes, that the check, it has a check mark there for August. I don't know when he paid it, though. I've never had anything to do with the payments.
Okay. It looks like it says last payment received August 2024. Is that correct?
That's what I assume, yes. That's what the thing said, yes.
And so currently your credit shows this amount past due as $43,000.
At that time it did. That would have been when I sent it, which was, if you can scroll up, I don't, that would have been as of December, because I think that was the last time, or credit report, January 17th, and then it shows, like, all of that, because I didn't know anything about the loan, so the only thing I had to go on was that. And the times I would call Wells Fargo, I would ask them if they could send me, like, any of the letters.
What you're asking for today is a judgment in your favor against Mr. Sibly in the amount of $43,022. Is that correct?
Yes, and all of the whatever fees, because it was somewhere around there, because Wells Fargo gave me something with, like, the total due, which it's about that 43,000. Oh, sorry.
And then in addition to that judgment, are you asking for a judgment on the contractual alimony of $24,500?
Yes.
Excuse me one moment. I just wanted to let the party and the attorneys know when I'm shaking my head, that usually means you're speaking too quickly at the moment. If you could
Okay.
just slow down a bit when that happens, then I will have to interject myself into the record. Thank you.
My apologies, Ms. Williamson. let's talk about the consulting agreement for a minute, Ms. Sibley. Have you in fact signed this consulting agreement?
I've signed a consulting agreement, yes. The consulting agreement, yes.
We have that as Exhibit 3. Signature. I don't see your signature on here. Let's see.
Page right there.
There it is. Okay, so it shows that you signed this on January 16th of 2025. And could you explain the reason you hadn't signed the previous consulting contract?
The one presented to me was not, it didn't reference our divorce decree. And that's what I wanted. I just wanted something to show that I'm signing this contract because our divorce decree said this is how you will receive payment. I never got one saying, referring to my divorce. That was all I ever wanted, to be based on fact. Like, you are a consultant as a result of the divorce decree, and you're going to be receiving this payment as that.
So this first sentence that says, according to the terms of the MSA and all that you're saying wasn't in the first contract.
Yeah, I don't think, no, it wasn't. I don't believe so.
Are you disagreeing with the terms in the decree that state that you have to claim the contractual alimony as income?
No, I'm not disagreeing with that.
Okay, will you complete a W-9 form if that's
Yeah.
what's required?
Yes.
Are you also asking for attorney's fees today?
Yes, and all the fees to make this come to a conclusion, and in case he doesn't fall through with doing all of the other pending obligations.
So let's clarify. So through today, you're asking for the amount of $30,000. Is that correct?
Yes, whatever. I think it's more than that, truthfully, but it's because he keeps making it more expensive.
And then in addition, you're asking in the event of a future appeal for fees related to that.
Yes, I can't afford to be my own attorney like him.
Your Honor, my mistake. I should have moved to enter Exhibits 8 and 3.
All right. Mr. Sibley, any objections to plaintiffs or petitioners Exhibit 8?
Then I need to look at them. 1 second. I don't have an objection to 3. I don't have an objection to 8 either.
All right, petitioners Exhibits 8 and 3 are admitted. And I'll add the court takes judicial notice of its file.
Thank you, Your Honor. Ms. Sibley, in addition to these payments, did you incur other expenses or costs when the car got repossessed?
Because besides having to take work days off, I had to go put, which is also still hard on me because I'm putting my legal fees on a credit card that I had to pay for a rental car for a month, and I'm just very lucky I got it, like, even it's a discount because I have it for so long, and it's like I'm gonna have to figure out something to do at the end of this week because it's the end of the month.
So you ended up renting a car and it goes through tomorrow, or?
No, it goes through March 30th after, like, yeah, the end of the month.
And I believe we have a copy. Do you recognize this document?
Yes,
What is this document?
that's the receipt for the total that I had to put on the credit card for renting it from I think like the Friday after the 18th, or yeah, it's from February to March, because I knew we were gonna have this meeting on the 27th, so I was hoping that I would have a resolution or something and I would be able to, but it's hard to even go look at a car because I have poor credit now. So it just sucks.
So in addition to the back pay on the contractual alimony, the judgment related to the car being repossessed, are you asking that you be reimbursed for this money?
If I can't, yes, I would, yes.
Did you have personal belongings in the car when it was repossessed?
A lot. It had a lot of my teacher stuff. I had a whole bunch of, yes, a ton of things. It was almost, yeah. It was all my markers, crayons. I was about to take things up to my classroom or like I needed to, because it was after January and I was like, oh, I gotta bring this back. But it was a ton of stuff, like cookies from Valentine's Day. I think I was still in there.
Did you get all of those items back?
I did. I had to go and drive to San Antonio. I had to take time off. That was a horrible experience. I am in a morning meeting, and my phone starts going off for my car alarm, and I'm thinking, oh no, somebody's breaking into the place where they repossess my car, wherever it is, and they're stealing my things. I call the police. Then I realized that it's not in Austin, that it's somewhere in San Antonio. So I'm thinking, oh no, like they've taken my car. They send me to a San Antonio police, and then they say that it's been moved. And so that was like 7:15, 7:20 in the morning. And I just remember thinking to myself, okay, I'm gonna have to go deal with this after work. And I go back to the class and I started my day. And my coworkers are actually the ones that said, Erica, you need to leave. You need to go take care of this because you don't understand, like, your car is like repossessed. Like, I don't know, like, I don't know if they knew all my stuff was in there, but as a result, I had to spend all day on the phone with banks, sending things and forms to where I could get my stuff, my car, my things out. I had to then spend the next day off of work because then they wouldn't release it. You had to have like a 24-hour like notice it. So and then they closed. So then I had to go Friday and drive to San Antonio to get my stuff out of my car. And I had to like carry all of this stuff like a long walk because they wouldn't even let it leave this area because they said Wells Fargo doesn't allow like miles on it or something.
So it's quite an ordeal.
Oh, I will never forget that traumatizing experience.
Yes. Your Honor, I'd move to admit Exhibit 10.
Any objection?
The objection, Your Honor, is that this is not a theory. I mean, what's the relevance here to admit this? So the claim is you didn't pay Wells Fargo. This is a consequential damages claim that somehow, because the car was repossessed, the person who didn't pay the note is now responsible for consequential damages. How is that? How is that? It's not disclosed. It's not in their motion. I mean, again, this has now been converted apparently to a trial on the merits. None of this was ever disclosed, and that's not a damages theory they pleaded. I mean, literally none of these documents were disclosed. None of them. And here we are at a trial. I mean, this is the problem.
All right. Had you sent discovery requests?
Your Honor, my answer was 30 days ago. The case just started. That's the whole point. I didn't even get, this was not designated as a trial setting. You're entitled to at least 45 days notice of a trial setting. This was a motion to enforce, and that's why we raised the objections we did, because the court can't just issue an order that says thou shalt pay it. We asked them to do it correctly, which is to set it for a trial.
All right. Are you seeking damages based on P10?
No, Your Honor.
All right. Then I'm going to sustain the objection.
Also, Your Honor, I thought that there was some requirement in your procedures that I saw that said this stuff was supposed to be disclosed like 2 weeks ago. I mean, do you see my concern with like getting this stuff dumped on me 2 hours before, and now we're treating this as though it's a final trial on the merits. This is why I think there's a lot of problems here that, I mean, it's just completely unfair. It's a due process issue. Even summary judgments, I get 21 days notice of what's in the summary judgment.
Mr. Sibley had plenty of time to send us discovery if he wanted to send us discovery. In fact, we sent him discovery. It was due yesterday and he did not respond. So he knew about this lawsuit actually in November. He just evaded service until we could get a motion and an order on alternative service in December. And then it was set in January. He knew about it then. He could have sent us discovery then. He has had well over 45 days. And we moved the hearing date based on his availability and his request. We're here today on his schedule.
Trial documents are supposed to be disclosed 30 days before trial. That's the day I filed my answer. This is why this is a 215 issue. All of this stuff should be barred under 215. I didn't get appropriate notice of trial.
All right. The objection is noted and overruled. Let's move on.
I'll pass the witness, Your Honor.
All right. Mr. Sibley, do you have any questions?
I do, Your Honor. Ms. Sibley, did you have you filed your taxes yet for tax year 2024?
No, I can't
Why not?
because I don't know what I have to claim or what I not have to claim based upon the contract that you won't sign now.
Okay, let me ask you, do you intend to claim, did you receive payments that purported to be pursuant to the final decree in 2024?
Yes,
How many payments?
from January to August.
Okay, do you intend to claim, is it your understanding that the agreement requires you to claim that as taxable income?
Yes,
Do you intend to do that?
yes.
So then what is the confusion about whether you're going to claim that as taxable income or not?
There was no confusing. My issue was when I had to change from when I went to my, what is it called? It was on my portal and work, and it says how much you earn and how much like potentially you have to save for withholdings. The thing it says how much money did you earn? I earn what I work for. That is my teaching job. I'm not receiving this money and it's not contingent on me doing or not doing anything. I'm not doing anything to earn it. But yes, I know I have to claim it for taxes. I don't know, like, I just don't, I don't know.
Well, you signed a consulting agreement to receive income, correct?
However it's worded that I've signed, that's what it is.
You know that it's called income tax, right?
I understand that. That's why I said I understand that I pay taxes on this.
But you don't consider it income.
Objection, Your Honor. Asked and answered.
Overruled.
What,
Do you consider the payments you received income or not?
however I'm supposed to file it is how I will file it. I haven't been able to do that because you won't sign it.
Who has someone told you that?
To my knowledge, you haven't signed the thing.
No, ma'am. I'm asking if someone told you that you can't file your taxes until that agreement's signed.
No, nobody's told me that.
Sorry, go ahead.
Nobody's told me that.
Okay. I want to introduce now, Your Honor. I guess I can share screen. It's going to make me open my system settings. Hang on. it's not gonna let me do it without quitting and reopening, unfortunately, because something about this program, but let me
Do you
just
have it in Box?
I'm sorry, Your Honor.
Have you uploaded it to Box?
It is in Box.
All right. Mr. Riggs, can you find it and share your screen? That'd be helpful. Thank you.
Okay. Do you see this email, Miss Sibley?
Yes.
Okay. Do you see where I'm trying to highlight here, but you see the fourth paragraph down?
Yes.
Says, as I told the lawyers.
Yes.
Says, as I told the lawyers months ago, and as I will tell you, I will never sign a contract saying I'm earning anything because I am not working to earn the money you have agreed to pay me as a result of our divorce. Do you see that?
Yes.
And so you made up, you decided months before April 15th, 2024, that you weren't going to sign anything saying you're earning anything, right?
No, you continue to read it. It says, I will sign a contract that references our divorce.
Yes,
I
ma'am,
wanted
but
the contract to represent the truth that I'm signing this contract as a result of the divorce decree because that's what I agreed to. That's what I said I would do.
you said you would sign a consulting agreement, correct?
Yes.
Okay, and you also agreed in that divorce decree to provide the appropriate tax documents so it could be reported as taxable income to you, did you not?
I don't know what tax documents that you have to give me to sign or whatever that go with it. I don't
Okay.
know. I just know that I agreed to sign a consulting agreement to receive the contractual alimony because that is the only way you would pay it to me.
And you were going to pay taxes on that, correct?
Yes.
As income, correct?
I don't know what it's filed under. I'm not a tax expert,
Okay.
but I agreed to pay taxes on it.
But you refused to sign an agreement that said it was income, correct?
I don't know if that's actually fully true because I actually signed an agreement on February 1st, 2024. But the lawyers said that the language wasn't right and that they had to fix the language. And then no other contract that I guess y'all could go back and forth on was something that you agreed with because I just wanted it to reference our divorce decree.
Would it surprise you to learn that Miss Andre never responded to requests to finalize that agreement after the divorce decree was signed? Would that surprise you?
Objection calls for speculation, assumes facts not in evidence.
Overruled. You may answer the question.
I don't understand the question. Repeat it.
Well, you just said that the lawyers could never reach agreement, right?
No, I'm saying like you as an individual, you wouldn't present a contract to me that referenced our divorce decree. I signed the one now and I'm paying the taxes on it, doesn't matter, but it refers to our divorce decree.
Okay, let me ask you this. I'm just looking, and let me go back to this provision here because. But you agree you're responsible to pay income taxes on the money you received last year pursuant to that agreement, correct?
If everything goes the way it was supposed to go and signed, whatever I'm supposed to do when I give it to whoever helps me with my taxes, because I don't know how to do the taxes. Like I don't do my own taxes. This is gonna be like I have to go figure it out. Whatever.
Can we pull up the final decree? Can we have Mr. Riggs do that, Your Honor? It's their exhibits. It's in their exhibit 2. All right, do you see where it says in the third paragraph, it is ordered under contractual alimony?
Joe Sibley is ordered?
It
Or
says it is ordered that Joseph Sibley, you see that,
Joseph Sibley is ordered?
right?
Yes, the first paragraph.
Okay. Look at the second sentence.
Joseph Sibley is ordered to pay as contractual alimony in the amount of $3,500 per month to Erica Sibley, with the first payment being due on the first day of January 1st, 2024.
So I'm going to stop you and just say you need to slow down a bit so the court reporter could catch all of your words. But I don't think that's the sentence he wanted you to read, is it?
The third paragraph, Your Honor.
The third under contractual alimony?
Correct.
And the second sentence that starts Erica Sibley?
Correct.
Okay. Erica Sibley shall claim any consulting payments received herein as taxable income and shall execute and provide all appropriate paperwork, including but not limited to a Form W-9 that are necessary to properly attribute to consulting payments as taxable income.
You agree to that, right?
Yes, I had to agree to that. That was my divorce decree.
Have you provided a W-9?
I don't know where I would get a W-9. You're the one who's making me sign saying I'm a contractor for you. I don't know.
So your answer is you did not provide a W-9, correct?
If you would have told me I had to provide a W-9, yes, I would have provided you a W-9. Is it something I can print off the internet?
Objection non-responsive, Your Honor.
Sustained.
You agree that this decree requires you to provide the W-9, correct?
It also says, yes.
Okay. And it says you're going to claim the consulting payments as taxable income, correct?
Because I have to because of the divorce decree, yes.
Okay. But it's pursuant to a consulting agreement, correct?
Sure.
Okay. And what you said earlier, I think, is until that agreement's signed, you don't really have to do any of that, right?
No, that's not.
Okay. Why did you, just to be clear, you didn't sign any agreement that was provided to me until after you filed this action for enforcement, correct?
No, that's not correct. I did sign an agreement prior to this whole entire thing,
When?
February 1st, but
Do you know
the
when that? Sorry, go ahead.
it wasn't right. But it wasn't right. The lawyers was like,
It wasn't provided to me, was it?
because it wasn't the right language.
Okay. Do you know whether your lawyers ever reached out and said, hey, let's keep working on this language so we can finalize the consulting?
Yes.
They
They
did?
did do that, Joe. They did that several times. That's why I had to pay so much more money for attorneys.
You were getting billed for communications from your lawyers to me about the consulting agreement?
No, for me, you drug it out.
Okay. I'm asking you between the time the decree was entered, January 26th of 2024, okay, and the time that you signed the agreement that we looked at in Exhibit 3, do you know whether your lawyers ever reached out to me and said, here's a proposed final version of the agreement, let's work out the details, or something like that?
They did.
How do you know that?
Because they would say, we sent this to Joe.
When did they do that?
Several times.
Tell me when the last time that they
I
did.
don't know, but I
Okay.
know it was back then, and it was me. Because they would ask me, is this good? And I'd be like, okay. And they were like, we haven't heard from him.
Your Honor, I need to object to this line of questioning, given the original counterclaim and third-party petition that Mr. Sibly filed today, personally naming me as a third-party defendant, asking for sanctions. It appears that he is attempting to ask my client questions related to this brand new lawsuit that has not even been served on me yet. He's also confusing the issue by going over and over the issue, which I believe was has she signed the consulting agreement? And will she claim the payments that she did receive, which sounds like was the first 8 months of 2025?
Before.
Will she claim that as income? And she's answered that many times in the affirmative.
I would disagree with that, Your Honor, but the question is designed to show that from the legal standpoint of a condition precedent, the consulting agreement is a condition precedent, and that wasn't done until after the suit was filed. And she also, she just admitted that.
Well, let's just stop for a minute. I've lost the thread of what the question was that there's an objection to. So let's go back and ask whatever the question is. And because the last question on my screen was, tell me when the last time.
And so I think the question, Your Honor, was when was the last time that her lawyers communicated with me about the substance of the consulting agreement, which she unilaterally signed in January of 2025?
I honestly don't know.
Okay. All right, let's talk about the Wells Fargo loan. There's some suggestion that you didn't know that you were on the loan?
No,
You didn't know? Is that your testimony?
I did not know who the loan was with.
I see. So you knew that you had a loan for the vehicle, but you didn't know it was with the Wells Fargo.
I didn't know who you chose to pick. No, I don't know that because you did the paperwork.
Okay.
You did everything. I didn't even know how much money it was. I didn't.
Did you agree? You're telling the court that you didn't agree to a loan installment agreement to pay for the Tesla Model Y.
I didn't sign any papers. No.
You didn't get an email from Tesla say agreeing to a loan agreement with Wells Fargo.
I don't know. No, I don't know what. No, because I don't know what I signed for. Like, I think we had to. No, I didn't, because the only thing I got from Tesla was an access to my app. That was all. I had to create an app or like a login for that. That's what she told me.
You showed us you showed us a document from, it looks like a credit check reporting service.
No, it's not a credit check reporting service. I think it was just like screenshots of like the report, but like it wasn't a service. Like I didn't.
Let's go ahead and pull down what's on the screen so we can see each other a little better. Thank you.
All right, but you obviously knew that the loan was with Wells Fargo because you were getting alerts from Wells Fargo, right?
I didn't know that until I started getting alerts, and I reached out to you and I asked you via email.
Objection not responsive after the last part of the question where she answers whether she got the alerts.
I reached out to you and said, Joe, I'm getting.
So the question was, you knew the loan was with Wells Fargo because you were getting alerts from Wells Fargo.
No, like.
Were you getting, let me just stop. The question is, were you getting alerts from Wells Fargo?
I got a little alert that says you're late on making payment. And I asked him, I said, Joe, is this true? And I said, or is this like one of those phishing scams where they're trying to pretend to be a bank? And he goes, oh, it's a phishing, ignore it. I said, okay, like good thing that I didn't do anything. Then I got another one, and that's when he lied to me. That's when I realized he was lying to me. And I said, you don't have to lie to me anymore. I'm no longer your wife. Please make the car payments on time and set automatic car payments like apparently you were making.
Okay, so somehow, some way, this loan that you didn't know you had with Wells Fargo, they happen to have your email address. And
they called me, yes. They started calling me, yes.
Okay. And so you knew there was a loan that you were on, you just didn't know it was with Wells Fargo before that, right?
I didn't know anything about the terms or who the loan was with or how much it was for or any of it. You always kept me in the dark. I didn't know anything.
You didn't see that in the final decree?
I knew that, yes, it was there, but I'm talking about when we first got it. No, I didn't know any of that.
Okay. All right. Did you ever make any payments to Wells Fargo on that loan?
No, I couldn't.
Okay. Did you ever, when the vehicle was repossessed, do you know whether it was sold?
I don't know.
Okay, so you don't know, sitting here today, whether that vehicle was sold and the amount applied to the loan, right?
I have no idea. I just know that they repossessed my car.
Okay, so you don't know what the current balance is in the Wells Fargo loan is, do you?
It was 43 something $1,000.
When was that?
Last time I think I talked to them, whenever I had to go get my stuff out the car, that was in February 19th. Or
Okay.
like after that, I think I called in March. Yeah, I called in March because I tried to delay it. Like I tried to ask them, they say you could do a one-time like delay of 10 days because I wanted it to get to the end of like to our trial today. Like I wanted to be able to have the car until the trial today. And so I'm hoping that like it's still there. I think it would have been till sometime like 10 days from sometime in March. So like, I don't know. I just know I don't have any more time.
So you haven't paid any money out of your pocket to Wells Fargo, correct?
No, I haven't been able to.
Okay, so the money on the loan is owed to Wells Fargo, correct?
No, I'm responsible for paying it because you saw it on my credit report.
So you want the court to order me to pay Wells Fargo, correct?
I want the court to order you to pay me what I need to replace the car and the amount of money it was valued at.
Well, how
Or
do we know
whatever
how
it
much?
is, or whatever the pleadings say, yes.
That's why I'm asking you, man. The pleadings don't say anything about a repossession or the value of a vehicle. I haven't seen anything
No,
on that.
that's not. We're asking for the amount of the loan.
So hang on. So Miss Williamson just threw up her hands, and the reason she threw up her hands is because Miss Sibly, you're speaking really quickly.
Sorry,
So-
I'm not used to.
And speaking at the same time.
I'm
Okay,
sorry.
so y'all need to speak one at a time. You need to wait for him to finish his question before you start your answer. And you need to speak more at a more normal speed, a slower speed. All right, so you may re-ask your question, Mr. Sibley.
You're asking the court so you don't want the court to order me to pay Wells Fargo, right?
I'm asking the court whatever I asked the court.
Okay. How do you know what the vehicle was valued at the time that it was repossessed?
Because I had to ask Wells Fargo. They told me that in order to get your car, you need to pay this amount.
Okay, but you don't know what the vehicle was valued at the time of repossession, do you?
It's whatever they told me I had to pay.
Objection, non-responsive.
So do you know what the car was valued at?
It was over $43,000. I don't know.
Your Honor, I think she's referring to the value of the loan and not the value of the vehicle. And I'm asking if she knows the value of the market value of the vehicle.
Babe,
Possess.
at one point in time, I did. Right now, I don't know.
Okay, so sitting here today, you don't have a value or an expert opinion to tell the court what the value of that Tesla Model Y was at the time it was repossessed, do you?
It was around $43,000
How do you know that?
because that's what the amount.
That was the amount of the loan, right?
No, the loan amount was like 67,000.
No, that was the amount of the loan at the time it was repossessed was 43,000, right?
Yes. I don't know.
Okay. So you don't know that the value of the vehicle was equal to the amount of the loan, do you?
It was. All I know was that Wells Fargo said you have to pay this amount of money to get your car back.
Okay. And you didn't pay them, did you?
I couldn't. With what money?
By the way, isn't it true that at the time of the marriage, you had defaulted on your student loans?
Objection relevance.
Your Honor, they brought her credit issues into the hearing.
All right, I'll overrule the objection.
My credit prior to this happening went from I worked so hard on it, to being almost at 800, and it's now below 650. I worked so hard to get my credit up, and now I have poor credit.
My question was, at the time that the marriage occurred, 2019, 2020 timeframe, isn't it true that you were defaulted on your student loans?
Yes, which is why I said I worked so hard to get out of,
And-
to
and
build
part-
up my credit again.
Okay. And part of rebuilding your credit was having you put on the loan for the Tesla Model Y so that your credit history could be built up, right?
That's what you told me.
Yes or no?
That's what you told me.
Okay, but how did you make all of the bills that were being paid on your credit were being paid by me, correct?
You said, I'm doing this to be nice to you. It will help your credit. That's what you told me.
And the Model Y was actually bought for you after we were separated, wasn't it?
No, we were still intimate
We weren't living in the same house, were we?
because you moved downtown and I knew that we could not live together. We were about to buy a house. That you canceled 2 days before closing.
Objection to the last part is not responsive, Your Honor. Did you object to the file being sealed?
No, what are you talking about?
Do you know why that the file wasn't sealed in this case until after you filed this action?
I don't know anything.
Okay. Have you destroyed all of the documents, the business documents you received in discovery from the divorce?
Yes, to my knowledge, I don't have anything.
When did you do that?
I don't remember after the divorce. There was like a deadline or something.
Okay. Do you recall whether there was an inquiry as to whether you had done that and you did not respond? Do you recall?
No, you sent an email. It was already done. My lawyers asked me and I said, yeah, everything's done to whatever we were supposed to do.
Okay. And I just want to revisit something quickly because I want to make sure I understand. It's your testimony and position here today that you haven't claimed the money you received, the $3,500 a month from last year on taxes for 2024 because I haven't signed the other part of the consulting agreement, right?
I haven't filed my taxes because I can't, because this is still going on.
But I thought you said earlier it's because I haven't signed the agreement. Is that not
It's
what you said?
because I can't, I need to know whatever is the conclusion of this case. You haven't been paying me alimony, so if I don't know if I get money, then I have to put more money on last year. I don't know. Like,
Have you
I don't
consulted
know
with
if,
a tax expert about this?
no, because I'm waiting on you to pay the rest of the contractual alimony as agreed to.
What does that have to do with whether you receive the money as income in 2024? We're in a different year.
No, it does matter because the contract that I signed is dated. It says as of this date. So if you pay it, then I have to put it for 2024.
The contract that you signed that's in Exhibit 3 says 2025, does it not?
But do you see at the top where it says it's per the alimony?
Can we pull that back up, Your Honor? It's there, Exhibit 3.
Your Honor, I have to object to this line of questioning. My client is not a CPA. She is not a tax expert. She stated she hasn't filed her taxes yet. She clearly needs to get advice about this issue. I'm not a tax attorney, so I can't advise her on this. She's already said that she will claim what she has received as income, and she's stating that she doesn't know if she gets paid for the missing months that she didn't get paid for 2024, does she also have to claim that as income? So that's, she's been asked multiple questions about this. She's answered to the best of her ability as a layperson, as Mr. Sibly so referred to as himself earlier, and he's asking for these interpretations of, quite frankly, some tax law that I can't even answer.
I'm having a hard time understanding how any of this is relevant to any issue that I might have to decide.
Well, I would argue it's relevant because the agreement says that the payments are to be made from a consulting agreement, which Erica agrees to sign. Erica said that she was not going to sign an agreement where she had to claim it as income. She just testified to that. It was only after this action was filed, after, according to the evidence, the payments were stopped, that she then signed an agreement that was dated in 2025. So then the question becomes, what about the tax consequences of the payments made in 2024? Because she didn't give a W-9, she didn't sign an agreement agreeing that that was income for 2024, and she's
So
saying,
Ms. Williamson is becoming so frustrated she threw her hands up. That's not a good sign. So I need you to slow down, please.
I'm sorry, I apologize. So this is the problem, right? Because if this is written off as consulting fees by the firm and she doesn't claim it as taxes and we don't have a W-9, there's problems with this. And so she actually said it herself that until the agreement is signed, she doesn't know what to do with it. Well, how was Mr. Sibly supposed to know what to do with it? If she hadn't signed it, refused to sign it, never indicated that she would sign it until after filing the enforcement action. That's why this is a problem. That's why our position is this is a condition precedent to performance because of exactly this issue. The tax payment should be within the taxable year that they're paid. And if we don't have an agreement for that being income, it's not clear whether the benefit of the bargain is there because it may not be, the tax consequences may be different. I agree. I'm not a tax lawyer either, but the agreement says W-9, didn't do it, says sign the consulting agreement and get the payments that way. It only says it's binding on me individually if the firm dissolves. There's no evidence the firm's dissolved. It was always supposed to be paid that way through the firm as a consulting fee, which she's claiming she didn't want to claim it because she didn't earn it, so it's not income. That's not how consulting fees work. That might be a W-2 employee. That's why you get an earned income credit for it, but not a W-9 employee. So I just wanted to look at the document, Your Honor. It's their Exhibit 3. I don't know what the problem is. It's their exhibit.
All right. And you can't pull it up yourself?
I have to reboot my entire Zoom. I recently got new software on the computer and it just not set up for it yet. So this is my first Zoom hearing since I've got it. If we scroll down just a little bit. Okay, so this says the effective date is January 1st, 2024, correct? Do you see that?
Yes.
Okay. And so if the back payments are made now, you're asking the court to award you the payments that weren't, according to you, weren't made in 2024, right?
All of the ones you missed.
Okay. And you don't know whether those tax consequences will be realized for 2024 or 2025, do you?
I don't know how to recognize this because I don't know how to recognize this. It's contractual alimony. That's a consultant thing that I just know I have to pay taxes on it.
Okay. Just a few follow-up questions. Why is it that you still have on your social media that we're married?
I don't have it on social media.
Objection, Your Honor. Mr. Sibly has filed yet another lawsuit in Hayes County claiming, I'm not even sure, libel, slander, or something, not
Defamation.
my wheelhouse. He's not only trying to relitigate this divorce in some of his questioning, but now he's reaching into another lawsuit that he just recently served my client with.
So how is it relevant to any issues the court needs to decide here about what she says on social media about whether you're married or not?
Well, because they filed something with this court claiming that they knew that I was married, and I'm just wondering why she would. It's just not clear why they would make that representation if on our social media it showed, being married to me still over a year after the fact that we were divorced. And so I'm wondering whether the things that are being filed, just been some questions that have some inconsistent answers about what the lawyers are supposedly telling me and what the lawyers are doing and what she knows. And I'm just confused about that, but I'll withdraw the question, Your Honor. All right, I passed the witness, Your Honor.
All right. Ms.
Your
Andre,
Honor,
do you have any more questions for Ms. Sibly?
I think just like one quick redirect, because I know that the court has a break at 3:45, and then after that, I think I'd be ready to move on with all my fees and get invoices and all of that taken care of. Ms. Sibly, at the time that we filed the motion or the second amended motion for enforcement, had Wells Fargo told you you could get your car back if you paid the 43,000 and change, 43 something?
Yes.
Objection calls for hearsay.
That's what they even presented me.
Objection.
Hang on. When he objects, what is your response, Ms. Andre?
Well, I believe earlier Mr. Sibly himself acknowledged this information. So I'm confused as to why he's now objecting to hearsay when this Mr. Sibly himself put this in his direct line of questions to my client. But
I asked about the value of the vehicle, Your Honor, not about the loan. That was her answer, was that she understood that was the amount of the loan, and we fleshed that out. And the cars are often upside down, so the amount of the loan and the value of the vehicle are not the same thing.
Ms. Sibly, if the court requires more information about this vehicle, are you willing to provide that information?
The last time I talked to Wells Fargo in early March, they said, you pay $43,000, you can have your car back.
Your Honor, the same.
All right. So I just want to remind you, Ms. Sibley, that you need to wait for her to finish her question before you start
I'm sorry.
answering.
I thought you did.
And you need to wait for me to finish speaking before you start saying anything, because the court reporter can't take two people down at the same time.
I apologize.
All right. So I think the point has been made, so let's move on.
No further questions, Your Honor.
All right. Anything else, Mr. Sibley?
No, Your Honor.
All right. So Miss Andre, you were going to move on to attorney's fees?
Yes, Your Honor. I have an affidavit in support of our fees, along with our invoices. I believe we have exhibits 13, and then all the invoices are 9.
Your Honor, here we go again with the how is it that in any trial, any case, how do you get the attorney's fee statement and there's no disclosure, there's no expert disclosure. They've given us no disclosures. Those are mandatory disclosures, by the way. I don't have to ask for those. We have no disclosure about attorney's fees amounts, about the testimony. None of the things that are required to get an award of attorney's fees, which requires expert testimony, by the way, have been done here. So how is this even allowed to go forward on this issue? I mean, I think the court should rule on the substantive issues. And again, I strongly object to that because it can't be don't agree that it can be done in this procedure. But once that's done, we can move to, whatever attorney fee contest that there is, because I don't know how it's possible that in a case where I don't know how it's possible they spent $30,000 in fees. I really don't. I do complex litigation, and that's a lot of fees, but I should have more time to deal with this issue and review the fee statements than a couple hours before the hearing. I mean, this is not a motion, even a motion for sanctions or something has fee statements attached or a summary judgment. You get 21 days notice. I get 2 hours notice for 30,000 in fees. How's that fair?
All right, so your objection to P13 and P9 is that you did not get them sufficiently in advance of the trial.
I didn't get notice this was a trial. But yes, I didn't get notice of any of this stuff. My answer was 30 days ago.
All right. The objection is overruled. P13 and P9 are admitted.
It's also hearsay, Your Honor. That's an affidavit. She has to testify.
So that objection is sustained, and that is to the affidavit. What's the date on that? I mean, which number is that?
The affidavit is P13, and I'm here, Your Honor, to testify. I was asking to admit the affidavit, but I was going to testify as to my affidavit as well.
All right. Well, so we will do that then. We're going to go ahead and take an afternoon break. We're going to break until 4 o'clock. You may review the materials. In the meantime, Mr. Sibly and Miss Andre, I will swear you in and allow you to testify. In the meantime, Mr. Beck, how much time do they have left?
Each side has 39 minutes left on the dot.
All right.
When are we coming back again, Your Honor? What time?
4 o'clock.
All right.
And y'all are welcome just to mute your microphone and stop your video.
Thanks.
Thank you, Your Honor.
Of course, they were late, so sorry about that.
Thank you, Your Honor.
All right. Miss Andre, I believe you were going to testify on your fees. Excuse me. So I'm going to ask you to raise your right hand and be sworn. Do you solemnly swear or affirm that the testimony you give here will be the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead.
Should I begin?
Yes, you may.
Thank you, Your Honor. My name is Amanda Andre. I'm an attorney licensed by the state of Texas and the founding partner, and actually only partner, at the firm of Andre Law P. LLC. My firm was retained by Erica Sibly on October 21st of 2024 to represent her in this motion for enforcement. I was licensed in 2003 and have practiced exclusively in the area of family law since that time. I was certified by the Texas Board of Legal Specialization in Family Law in 2008, and I'm currently practicing primarily Travis County, Hays County, Williamson County, and a few surrounding counties in Texas. I am familiar with the factors enumerated under the Texas Disciplinary Rules of Conduct 1.04, as well as the case law and the other factors to determine the reasonableness of my fees and my hourly rate. I'm also familiar with the facts of this case and the costs and fees incurred in representing Erica Sibly. I am the lead attorney in this case, but when appropriate, I would seek the assistance of my associate attorney as well as our paralegal and legal assistant in this matter. My currently hourly rate, my hourly rate on this matter is $500 an hour, which is reasonable and customary and actually lower than many of my colleagues with my same level of experience and specialization. I had a former associate, Mr. Garcia, who worked on this case at the rate of $300 per hour. and he had been licensed since 2024, but had worked in family law for 2 years prior to that. His fee was reasonable and customary for attorneys at that level in Travis County. Mr. Riggs is an associate attorney currently. He's been licensed since 2020 and has practiced exclusively in the field of family law. And his rate is $400 per hour on this matter, which is also reasonable and customary for attorneys with similar experience as his. And Miss Baker is currently a paralegal with our firm at the rate of $175 per hour in this case, which is also reasonable and customary for a paralegal with similar experience in Travis County. I believe we've already admitted my invoices, which go up to today's date, or maybe yesterday's date. I apologize. These bills are kept and maintained in the regular course and scope of my representation of Erica Sibly, just like other clients. The records have not been changed, modified in any way other than some minor redactions of attorney-client privileged information. It is my opinion that the fees and case expenses incurred by Ms. Sibly were reasonable and necessary, given the matter here. We've had multiple amended motions due to change of events that occurred, particularly with the car. Motion and order for alternative service. We had extensive case law research due to the responses that were filed by Mr. Sibly. We did prepare and send discovery. We did prepare for the hearing today. So the total fees through today are $30,734. My client has also asked for fees in the event of an appeal in the amount of $25,000. And I believe, Your Honor, P13 was not admitted. I was going to ask the court to reconsider the last 2 pages of that exhibit, which summarizes the by month and by the person billing, how much work. It just demonstrates that whenever possible, I limited my time to keep the fees lower in this matter. And you'll see, you know, if this exhibit gets admitted, that my fees didn't go really up until the month of March, when also Mr. Sibly had filed multiple other motions and, well, a new lawsuit.
I'm pulling it up now.
Thank you, Your Honor.
So it appears that the affidavit is now simply a summary of what you've already testified to, but the Exhibit A is a summary of the work done. It's just a compilation that's different from your invoices that groups the work together.
Correct.
All right. Any objections, Mr. Sibly?
Gonna have to look at it again. Give me 1 second. I mean, I object to it as cumulative, Your Honor. She has the fee statements in, so what is this? I mean, what do we, this is too vague. It just says enforcement work. I don't know what that means. I mean, the attorney's fee statements speak for themselves, and so I'm not sure how this is, just not sure how this is helpful as a summary.
All right. The objection is overruled and P13 is admitted. Anything else, Ms. Andre?
No, Your Honor, thank you.
All right. Mr. Sibly, do you have any questions for Ms. Andre?
I do, Your Honor.
Okay.
Ms. Andre, when you filed the second amended motion to enforce, you included a provision that requests that the court admonish Joseph Sibly that violations of the agreed final decree of divorce may lead to sanctions, contempt, and fines, correct?
I believe it said future violations.
Well, what kind of future violations might there be that would result in that?
I'm not sure. There are several outstanding obligations in the decree that have not been complied with yet.
Okay. You initially requested an order to show cause in connection with this case, didn't you?
I apparently so. I would have to look back in the file.
Yeah, well, I mean, you claim to be familiar with the file. You're testifying on your attorney's fees, right?
Yes, I don't have the invoices up, but if you got a show cause order, then we requested a show cause order.
Right. And a show cause order is something you do with respect to a contempt hearing, isn't it?
We always do it with a motion for enforcement.
You always do it with a motion for enforcement?
Yes.
Are you talking about the order to appear?
Oh,
I'm sorry. Will
Well,
you
there's
tell
an-
me what you're speaking about? I just want to pull it up.
There's some orders to appear. It's got some references to show cause and some of the, I don't know exactly where it's at, but I mean, the file speaks for itself, but an order to appear is, well, you would agree with me, Ms. Andre, an order to appear is not a notice of trial setting, is it?
it's a notice of a setting.
But it's not a notice of trial setting, is it?
I'm not sure what you're trying to ask me.
Do you know what a trial is?
Yes,
Okay. Did you give a notice of a trial setting in this case? Yes or no?
you agreed to the setting today.
Objection non-responsive.
Overruled.
Did you give a notice of a trial setting?
I don't believe so. We agreed to the setting today.
On a motion, hearing on a motion to enforce, right?
Yeah, that's what we filed, the motion for
Okay.
enforcement.
Right. Okay, you have a proposed disposition of issues that you filed as well, didn't you?
I believe we have one, yes, as an exhibit.
Okay. And you're asking the court to admonish Joseph Sibley that future violations of the agreed decree of divorce may lead to further orders from the court, sanctions and or fines, right?
Yes,
Like
that's
what? Give me some examples of what would lead to sanctions, fines, things like that.
well, I don't know until you violate the decree further. Like I said, there's other outstanding obligations in the decree.
Okay, but you agree that
You
debt,
haven't answered any of my questions on so far. And you
Okay.
provided our client no information about those outstanding obligations either.
okay, but you agree that it's inappropriate to threaten contempt over non-payment of contractual alimony. Would you agree?
I didn't threaten contempt. That
Objection non-responsive.
There's no contempt in my motion. Sorry,
The
Mrs.
question is, you agree it's inappropriate, don't you?
Do I agree it's inappropriate to ask for contempt for contractual alimony? Yes, I didn't ask for contempt for contractual alimony.
Okay. You did there's a lot of work here about a default, research on a default in January. Do you recall that?
I would have to look at my invoice.
Okay.
I think that might have been related to the things you were filing.
Well, I didn't make an appearance in this case until February, right?
No, but you wrote my office very long emails.
When was that?
I think the first one was October 29th of 2024, if I recall.
Okay, when was the next one?
I would have to go back and look. I don't have all these dates memorized.
Okay. You initially had this set for hearing in January, did you not?
I believe so.
Okay. And you purported to serve process by having your assistant email a copy of the citation to me, did you not?
If that mistake was made, I guess that mistake was made.
Right. So you prepared for a hearing that you provided bad service on, right?
I didn't charge for preparing for a hearing in January.
You're telling me there's no hearing preparation time on your fee statements for January?
Not for me.
But you're billing for your assistants for a hearing preparation that didn't happen because you didn't effect proper service, correct?
which we used for today's hearing.
Okay. But the answer is yes, you prepared for a hearing in January where you had given actually bad service, right?
If that's what the invoices show, I guess that's what they show, is that we didn't have proper service, and so we moved the hearing.
Did you make any disclosures in this case?
Not required to.
You don't think you're required to make
You did not send me a request for this.
Okay.
One at a time, please.
So it's your testimony. There's no mandatory disclosures in this case.
No,
And you didn't make any disclosures at all, did you?
I never received a request for disclosures from you.
Okay. Okay, but the answer to the question is you never made any disclosures. I didn't ask you if I sent you disclosures. You didn't make disclosures, did you?
Not required to.
Your Honor,
What's the rule, Miss Andre, on that excludes family law cases from automatic disclosures?
It changed, I believe it's 194. I don't have my book in front of me.
Yeah.
It's just a simple question. I mean, we can.
It changed. We were subject to initial disclosures for a period of about 2 years. And that changed, I want to say September 1st of
23. I found it.
23.
194.1, and it does exclude suits governed by the family code as of September 1, 2023.
I'm talking about trial disclosures. You didn't make any trial disclosures 30 days prior, did you?
No.
Okay. You didn't disclose yourself as an expert, did you?
No.
All right, let's talk about this back and forth with the consulting agreement. Your client has testified that there were all these emails that went back and forth between you and I about the consulting agreement. When is the last time that you emailed me or contacted me about the consulting agreement?
I don't know what that has to do with my fees today, other than I did send you, or my staff sent you a copy of the signed consulting agreement. I want to say mid-January, and sent you a Dropbox for you to sign the same one that she signed.
Okay, but before that, when was the last time you contacted me about that agreement?
During this case, I don't recall.
Before the case was filed, ma'am.
I don't know.
Isn't it true that you received emails from me inquiring about sealing the file, about the consulting agreement that you didn't respond to?
No.
That's not true?
Yeah, I'm, Your Honor, I have to step out. I need to object to this because he's asking questions that were before this lawsuit was even filed. And he's asking questions, I think, trying to gain some information related to this original counterclaim and third-party petition that he filed just before our hearing today.
All right. The objection to asking questions for anything before this suit was filed is sustained.
I'm sorry. Why can I not ask her fact questions that relate to the underlying issues about the consulting agreement? She's a fact witness. Her client just said that she relied on her to email me about the consulting agreement.
So you may ask her any questions you like about what happened after the decree of divorce and that relate to whether you think her fees are reasonable or unreasonable. Is that what you want to do?
I want to ask her questions about what happened after the decree was signed and we attempted to finalize the consulting agreement, because her client has just testified that supposedly Miss Andre was back and forth with me about the wording of the agreement. So I'm asking questions about that. Miss Andre is also a fact witness now, in addition to testifying about her fees in this case.
Well, I'm gonna allow her to answer questions as an expert witness, but no, I don't believe she's a fact witness at this point.
So you're going to disallow me to ask her questions as a fact witness, just so we're clear.
Correct.
Okay. Back to this disclosure issue. If I had sent you request for production, request for disclosure the day that I answered the case, that would have been due yesterday, right?
I believe so.
Yeah. And so you think 1 day is sufficient time to review documents, take depositions? You would have made Miss Sibly available for deposition?
You didn't ask for a deposition.
Okay, but you would have made her available like within the last 24 hours?
Maybe.
Okay. All right. Yeah, it doesn't matter. I passed the witness.
Did you have anything you wanted to add, Miss Andre?
No, Your Honor, thank you.
All right. Is there any other witnesses or evidence you want to put on?
No, Your Honor.
All right, so you rest.
Yes, Your Honor.
All right, Mr. Sibley, is there any other evidence you want to put on?
I don't have any other evidence to put on. I do have some closing arguments, if I may make at some point.
All right, so both sides rest and close the evidence?
Yes, I do.
Yes, Your Honor.
All right. Then, Miss Andre, you may make a closing argument first, and then Mr. Sibley, and then you may make any rebuttal within the time constraints that you have available. Mr. Beck, how much time do they each have left?
Ms. Andre has 32, Mr. Sibley has 26, so there's absolutely no obligation to use all of it.
True. All right. Go ahead, Miss Andre.
Thank you, Your Honor. I will attempt to be brief in this. I think by Mr. Sibley's own admission, both today and in his pleadings, it's clear that he stopped paying the contractual alimony in August of 2024 and stopped making the Tesla loan payments on the vehicle that was awarded to Miss Sibly in August of 2024. Additionally, the court can now infer from his pleading the fifth that these payments have not been made. He also indicated that he doesn't intend to make the future payments. And he's
I'm sorry, hang on a second. Miss Williamson, you have your hand up?
Judge, I am striking keys over here, and sometimes my commands to my software go to Zoom, so you may lower my hand. But I did close my camera so y'all could stop seeing me shake my head.
No, go ahead and please leave it back on there and let them look and see if they are going too fast. All right. Go
I
ahead.
apologize if I'm speaking too fast. I'm trying to slow it down, Miss Williamson. Miss Sibly is asking for a judgment in favor of the contractual alimony payments, which as of today, she's owed $24,500 plus 6% interest. In addition to that, she's asking for a judgment for the car. Loan balance was $43,022.26 with 6% interest. A judgment to her, not to Wells Fargo. And we would offer, Your Honor, if the court needs more information about the status of the vehicle, that we get some time to obtain those documents from Wells Fargo, and we will share them with Mr. Sibly, whether, Miss Sibley is able to get the 43,000 and go get her car, or she will have to just find a completely different vehicle. She's also asking for the 30,000 in fees through today, as well as 25,000 in the event of an appeal.
All right.
Thank you, Your Honor.
Thank you. Mr. Sibley.
So again, Your Honor, this is completely and utterly unfair position that I've been put in here. There's no way that you can expect someone to have a trial on the merits. This was not noticed as a trial. A motion to enforce is not a trial of the merits. And so I've been put in a situation where there are these veiled threats of contempt, okay, fines, etc. And when I tried to get that cleared up, I couldn't even get a basic ruling from the court that that was off the table. So unfortunately, it prejudiced me. Or I'm literally having to plead the fifth for something that is black letter law. We shouldn't be talking about it. This is, under no circumstances could anyone have been able to develop a case in the amount of, assuming this was even properly noticed as a trial, which we would have objected to if we knew it was a trial. I mean, this is not a trial. This was a motion to enforce, which means they want an order from you that says, thou shalt do this. You don't get that. You can't even get that in a summary judgment. I'm in a worse position now than I would have been in a summary judgment. At least a summary judgment, I get fair notice. And I respectfully disagree that there are not jury issues here. This is a case that arises, this is a case that says it's governed by the Texas Rules of Civil Procedure. If you bring an action to enforce, yes, the court's division of property is not subject to a jury trial. That's true. But we have fact questions on the enforceability of this contract. I've cited the cases for you that say we can raise affirmative defenses to the enforcement of the contract, and that's been done. And based on Ms. Sibley's own testimony, there's at least a fact question as to whether she ever intended to sign a consulting agreement, whether she's provided she's testified she didn't do it, and it wasn't done until a month or so ago after this case was filed, didn't provide a W-9, is ambiguous about whether she's even going to claim it on taxes. And as far as the Wells Fargo thing goes, I'm sorry, but they can't submit things after the hearing. They don't have any evidence of the value of this vehicle. That's very clear, even though Ms. Andre's statements claim that they were trying to get a value of it. It's in her fee statements. Didn't happen. So they don't have any expert testimony or any competent testimony to testify about the value of the vehicle. Well, where does that leave us? Well, the case law says that in order to, you can't order me to pay a third party, right? That's not something you can do. You could only order me to pay her amounts of money. It would be a judgment, not really an order, but it would be a judgment that would reimburse her for the money she paid to Wells Fargo. She hasn't paid any. So that claim is dead on arrival. You don't get consequential damages from the failure to pay a third-party debt. So what she would have needed to do was to make the payments herself and then come seek reimbursement for those payments. She didn't do that. We don't know what the car was sold for. We don't know, what the current balance of the loan is, but anything along those lines, that would have to be, that's vis-a-vis Wells Fargo. That's not vis-a-vis her. In summary, Your Honor, this is, I'm honestly, I feel like I'm in the Twilight Zone. I got a notice of a hearing on a motion. That's not a trial. We were not noticed for any trial in the merits. And then this magically transformed into a trial in the merits within the last 24 hours or so. When I get these exhibits and the request for final disposition of the issues, we have counterclaims alive too. We haven't had any, how can anyone be expected to get ready for a trial that fast? That is insane. The rules of civil procedure apply. There was no notice of trial setting given, and the notice has to be done at least 45 days before the trial setting. This was a hearing on a motion. You cannot win on these claims under a motion. even the case that Miss Andre cited for you, and or didn't cite it, but she put it in her folder of extra materials, this Griffith versus Reyes, you can bring an action to enforce, not a motion. You bring an action to enforce there, and they talk about first amended petition, second amended petition, answer. It's just like it says in the family code. It's got to be done like a normal civil litigation. But no chance whatsoever to meaningfully develop our defenses, to take the appropriate discovery, and we're doing so under this veil of, oh, you might get fined. I mean, notice how Miss Andre is very cryptic about what that is. I mean, this has no place here. Okay, it's completely ridiculous, and this is really the reason why she wants to talk about how we got here. This is really the reason why we got here in the first place. I would have never agreed to any of this stuff under a lot of circumstances, including the fact that, they always told me that, you'll always be treated poorly when you go to Travis County courts because, of who you are. And I'm really upset about the way that I've been treated today. This should not have gone forward. This is completely unfair. And I mean, unfortunately, I'm not surprised because it's happened to me before, but here we are. So.
All right, Miss Andre, do you have anything you want to add by way of rebuttal?
Well, the level of unfairness here is really as to my client, right? She relied on these agreements that were reached in a binding mediated settlement agreement, then put into a final decree of divorce in a court order that was not appealed, that she started receiving the payments on, and then all of a sudden stops. She's a teacher. She doesn't make the kind of money that Mr. Sibly makes to even afford to pay the car payment, which was over $1,000 a month. We followed the Texas Family Code rules, and we followed the rules of procedure in getting alternate service while Mr. Sibly was evading service. There may have been a mistake when my assistant emailed him the first motion, but we're not here on the first motion. We're here on the second amended motion, and we're here today based on his request, his dates that he gave us for a hearing for today. And under Chapter 9, he is not entitled to a jury trial. And Chapter 9 is exactly how you enforce property division in a divorce, including any contractual provisions. And again, we haven't asked for contempt. We're just asking that she be made whole as she should be today per the terms of the decree. Mr. Sibly can pursue his breach of contract related to the consulting agreement. However, she has now signed it. If he doesn't agree with the terms that we put in the consulting agreement, I guess he can debate with her about that. I'm not sure what to do about that. Again, our client, she just needs to be made whole. That's it.
All right. Thank you. I am going to take this under advisement and review the various cases and provisions y'all have referred to. And I will get you all a decision as quickly as I can.
When do you, and I know you're busy, Your Honor. But how long do you expect? I mean, do you have any kind of time, like general time frame?
I will attempt to get you all a decision in the next couple of weeks.
Thank you, Your Honor.
All right. Thank y'all.
Thank you, Your Honor.
Everyone is excused.
Thank you, Your Honor.